Alliance for Finance. Thank you all for attending, and thank you also to our good friend David Sorensen from Morrish Solicitors for providing the second update of the year for the Alliance for Finance and its affiliates. There'll be time for any questions at the end of the presentation, so just please add your questions to the chat functionality as we go along. David, I'm sure this is going to be an interesting update, and so I'll hand over to you so that you can get started with your presentation. Thank you.
Thanks very much, Anya, and good morning, everybody. As Anya said, I'm David Sorensen. I'm an employment lawyer by trade. I've been doing it for the best part of 25 years now, which feels like a little while. And I'm going to talk today about the proposed changes by the new-ish still Labour government, and also a couple of cases, recent important cases, tacked on at the end. And Chris is hopefully going to move us through the slides as we go through it. So if we could just move on a little bit to, just a little bit about us, and hopefully you're aware of who we are. We're now pretty much the UK's second largest trade union law firm, and we act for over 30 unions and associations, and many friends online here, which is wonderful to see. We act for individuals, not for companies. And as can be seen on the next slide, we cover a full range of services. And obviously, if you need any information on those, feel free to ask. But then if we could just move on to the next slide, and we'll look at the agenda of what we're covering initially. Now, I think the significance of the Employment Rights Bill and the new government's changes is somewhat understated in many quarters. And I just quote really a quote from Unison Legal Services in terms of their view on it, which is: the depth and scale of reform is breathtaking and will affect every worker, trade union and employer. And I agree with that. Also, the government says this is the biggest upgrade in employment rights for a generation. I think that actually understates it. In my sort of actual experience, this is really probably the biggest employment rights change in one go that I've seen, and I think that can be identified in the country's history, really, because there's quite a significant amount, and I'm going to try and cover those in detail today. We haven't got all the details because they're not actually going to come in, most of them, until autumn 2026. So there's a whole lead-in time going on there, and no doubt there's political factors involved there, but also the importance of the government showing they're doing adequate consultation with the affected stakeholders, business, unions, individuals, charities, and so on. So that process has to be gone through, but also is intended to give quite a bit of preparation time. But I think whilst at first blush, 2026 seems a heck of a long time away, actually, when you look at the detail of what's coming, I think it's going to take some time to work through. I'd personally like these to come in quicker, maybe late next year, as opposed to sort of autumn 26. But there's quite a lot to cover. So I will start by going through what we're going to cover, things like unfair dismissal, fire and rehire, and we'll go through them, and I'll sort of explain what's involved. I am going to refer to my notes because there's quite a bit of detail, and because a lot of this typical lawyer hasn't come in yet, it's not quite fully sunk into my brain what is coming, because I think my brain says, because I'm used to 14 years of Conservative government, well, lots of things are told we're going to get, but never actually arrive. So I think I have a sort of self-delete mechanism. So I'll have to refer to my notes to remember it all. But I do get the feeling that a lot of this is going to come in, and there's a lot of good stuff in it, which is terrific. So if we can just move to the next slide and look at unfair dismissal. And I think this is quite well known, so not much of this will be a surprise at this stage. But I think what I'll try and do is provide some clarity as to the best indication of what is likely to come and how it's likely to shape. So what the government has identified is there are currently approximately 9 million workers in the country who have less than 2 years service, and therefore don't currently have what we would call ordinary unfair dismissal rights that you currently need 2 years service to gain. There is, of course, automatically unfair dismissal protections Many of those apply from day one, but they're only for specific circumstances like dismiss because of raising a health and safety complaint, dismiss because being a trade union member, things like that. So what we're focused on here is ordinary unfair dismissal. And the plan really is to bring in ordinary unfair dismissal as a day one right, but with what looks to be a 9-month qualifying statutory trial period. So that would be a 9-month trial period in which it is more straightforward for an employer to dismiss. So we're looking still at a day one right, but it looks like we're going to have a 9-month statutory probationary period in effect. So where the employer and the employee can trial out the relationship, and it will almost certainly allow a process to be followed to dismiss fairly within that 9 months. But then what we anticipate is then ordinary unfair dismissal rights will apply. So that is a significant improvement. So, and if we move on to the next slide, that then links to fire and rehire, because of course we're all aware of the awful treatment of the maritime workers and by P&O and the terrible situation there. And we've no doubt all experienced similar situations, because it's a fairly shocking truth that it is probably more straightforward currently to fire and rehire workers in this country than it is in many other similar sized economies, even just across the channel. So it is we're often an easier target because it's cheaper and more flexible to do it now. So what we want to look at is what is proposed to be changed. And again, I quote the government, so which is using good language, says the government wants to end unscrupulous fire and rehire tactics that leave working people at the mercy of bullying threats. So this means, in a nutshell, it will become automatically unfair to dismiss employees in certain circumstances. So automatically unfair to dismiss employees to replace or to re-engage them on varied terms. So the watering down terms and conditions that we've seen on many occasions, attempts be made to do that. So that would be automatically unfair. Secondly, for failing to agree to a change in their contract of employment, so failing to accept it. So those sort of situations are protected unless, and there are some exceptions, the employer can show, currently it appears to be 3 things the employer's got to show to be able to do it fairly and for it not to be an automatically unfair dismissal. If they can show, I'll go through the list, evidence of financial difficulties that were affecting or were likely to affect the business's viability. So it's obviously serious financial difficulties to affect the viability of the business. Secondly, the changes were to eliminate, prevent, alter the effect of those difficulties. And thirdly, the need to make the change to any terms and conditions was unavoidable. So that's quite a high bar to hit. And that looks promising from our point of view, to make it harder for an employer to fire and rehire, fire and replace in those circumstances without showing that it's very important, or obviously could threaten the very viability of the business. So that's quite a high bar, and we'd like to see that followed through, so that protection's in place, because that will hopefully help avoid fire and rehire when it's simply making more profits, rather than actually fire and rehire when it's the survivability of the business that's threatened. I don't think anybody would say that P&O Ferries business viability was a threat. It was more a case of maximising profits, cutting costs and so on. So that's quite a high bar. And even where the employer can hit that high bar, what then applies is the current reasonable test. So it has to show an employment tribunal would have to decide whether the dismissal, with that bar being hit, even so, whether that dismissal was fair in all the circumstances. So was there consultation with a recognised trade union, individual consultation, were proposals put forward, was there engagement and so on, going backwards and forwards before those were implemented. So that looks really helpful and actually gives some, on the face of it, some teeth here to the protections. And the government's aims to benefit two kind of groups, and they've identified that. Firstly, the employees themselves. So terms and conditions can't just be ripped up under threat of dismissal. And the idea here is to help grow the economy so that people are more financially individually secure, but also they can plan ahead and save money for the future, making the individuals and families more secure, which is a very good aim. But also to benefit, secondly, good employers, those who don't want to carry out a business that just undercuts rivals by cutting terms and conditions of employment, firing and rehiring staff. So to try and encourage good practice, which is also important, because there are certainly some bad ones out there in terms of employers, but there are some pretty good ones as well who are sort of undercut by the bad ones. So it's trying to, the idea is sort of the rising tide lifts all ships is the aim there, which sounds a valid one. So that's interesting. And then that then links into the next slide. So it's a package of, let's just go back to improved unfair dismissal rights in terms of day one rights subject to a probationary period. Secondly, trying to limit fire and rehire practices. And thirdly, improving protections against collective redundancies. And again, forgive me, but there's a number of factors here as well that can be very beneficial. Firstly, of course, currently there is a duty on the employer to inform and consult when 20 or more redundancies are proposed. And the current test is that number of 20 or more applies to one establishment. And there's the old Woolworths case that some of you may remember, where the law identified that the establishment is the actual workplace. And that would typically be one site. So that could be a factory, but equally it could be a shop. And of course, if there's only 15 people in the store or in the branch, then they would not be covered currently, except for some exceptional circumstances where maybe stores were linked together. But again, the kind of direction of current travel, the current law as it is that it's one establishment. The proposal is that 20 or more applies across the employer, which is brilliant from our point of view, because that allows all workplaces to be joined together. So if the employer is proposing 20 or more redundancies across its workforce, that will be triggered, no matter if there's only, say, 2 in Aberdeen, 2 in Thetford, 2 in Doncaster, those could be added together within the business. If that comes through, then that will certainly lift the protections and make it more difficult for an employer to try and get around that protection. So that's a protection for the duty to inform and consult when there's 20 or more employees proposed to be dismissed. And if that, as I'm sure you know, if the employer breaches that, then there is a claim for a protective award, and a protective award is up to 3 months' pay. The government is looking at increasing the maximum protective award, or potentially making the protective award in some way uncapped, which would be incredible. I'd be surprised if they make it uncapped, because that seems that could very much give, to an extent, kind of unlimited compensation. I would imagine they may increase the cap, but increasing it beyond a 3-month award would be brilliant, and of course bring us closer to the protections you'd find, say, across the water in the Netherlands or somewhere like that. So where again, international businesses tend to choose the country to make redundancies by the cost involved, and so increasing that would be excellent. But then, in addition to that, amazingly, the government are thinking about allowing a protective award claim to become a form of interim relief. Now, that is effectively like an injunction. So the consultation is about whether, in this situation where the employer has not informed and consulted correctly, and where the union's recognised, the union could bring a claim for an injunction potentially to stop the employer carrying out the redundancies. Or the other variety of that could be, it could be the same type of claim that we brought now. So not injunction to stop, but a claim to bring a protective award, and an emergency hearing within 7 to 14 days of the application in an employment tribunal to make the protective award. So there's two ways of doing it. So I'll be can't wait to see the detail of this. Again, there isn't enough detail yet to confirm which way they go, but these powers could be significantly strengthened. And if that happens, then it will be very expensive and very tricky compared to how it is now for an employer to make large-scale redundancies without going through a very detailed process. And of course, in my opinion, the bigger the fines or the bigger the cost to the employer, the more likely they're going to take proper preventative medicine to make sure that unions, employee representatives, and so on are informed and consulted with. So some real powers here. So I think we can be quite positive about this in terms of individual unfair dismissal rights, fire and rehire protections improving, but also collective redundancy situations, those rights being strengthened as well. So moving on to the next slide, we can look at trade unions. Now I'm going to have to refer to my notes here because there's quite a lot of positive trade union changes, and I've just done a brief list here. But I suppose taking it from the top, there is a move to take the industrial action legislation that the previous Conservative governments have brought in back to 2015. What does that mean? Well, it means removing some of the additional requirements on percentages, particularly in important public services, also additional requirements on supervision of pickets, and that the indication is that the appointment of a picketing supervisor will be removed. It also would allow they're proposing e-balloting, electronic balloting, rather than the current postal balloting process. And previous Conservative governments have looked at the postal balloting and said, oh no, we'll keep that in place, please. And of course, the reason they've done that is because of the enormous cost of the postal ballot, given the fact, a first class stamp these days is £1.70 and so on. So the cost is huge. So looking at e-balloting and improving those. And so those are really important changes. But it's not just that. There's also proposal for a statement of trade union rights, so that every new employee, potentially every new worker, will have a statement within their written particulars identifying their right to join a union and maybe identifying the union within the workplace. It will also potentially allow much more access to the workplace by unions too. Now, this is a complicated process that's proposed, which is to set up a framework of access agreements between an employer and a trade union, which would be supervised by the Central Arbitration Committee. So it seems quite complicated, the proposal so far, but would allow a form to be completed, sent to the employer responds, access should be given. So it's going to be a kind of formalised process, but it would set up a formal framework allowing access to the workplace, allowing the union to promote itself within the workplace. And so it's, again, the details yet to be seen, but it seems a positive. And also it makes clear that the purpose from the government proposals is to, quote, represent, recruit or organise members and to facilitate collective bargaining. So that's really interesting and a really positive proposal. And linked to that is also a similar duty for union access to improve equality in the workplace and setting up a system of statutory equality reps to help reduce sexual harassment, help improve diversity and equality in the workplace. So we need more detail on this. But again, this is a right of access that's emerging that seems quite positive. My only concern is it seems quite a complex process, and also it's one which will allow complaints to be made to the CAC and dealt with through the CAC. And of course, it's a question of resources to how that works. But subject to additional resources being given, and we'll talk about that in a bit, because there are other potential bodies like ACAS and the employment tribunals who need more resource to deal with the extra workload, but it could be a really, really positive improvement. A simplification, then we're sort of looking at the rules for moving on to the next, the rules concerning trade union recognition. And again, there's a recognition, if you forgive the pun, the union recognition really isn't a very effective and efficient process currently. And I think, you know, those who know the history, I think will know that this is the old sort of Murdoch exception where Tony Blair and Alistair Campbell and so on were sort of leaned on by Rupert Murdoch to water down statutory recognition, making it a very complicated and not quite toothless, but a very difficult process. But in a nutshell, the proposal is to simplify the process and also to bring down the percentages of employees in favour of recognition. So possibly changing those and allowing some of the requirements for membership to be reduced down to maybe even 2% rather than 10%. And so again, we need more detail here, but the good news is that within the government documents, there's again a recognition that this process ain't good enough and it needs to be improved. Just a little bit, sorry, just a bit more on the trade union side, because there's a large amount of stuff here, and I'll cover as much as I can. But there's then an extension of facility time as well. So for union representatives in the workplace, and again, specifically also for equality reps and equality improvements in the workplace and powers there. Helpfully, I mean, there's some wonderful stats within the government, and we will put more information out on it. But the government has started, as part of this process, actually, and this is so refreshing to the previous Conservative government drafts for any employment law changes, which frankly were mainly in favour of employers rather than employees or workers. But there are stats which the previous government had that show the contribution of unions to the workplace and the benefits to society, which vary, but effectively are in the hundreds of millions in terms of the benefit to society of unions in the workplace, of union workplace representatives, of improvements in health and safety, improvements of equality in pay. I mean, these things we know, but to see it actually set out in detail, like I say, I will send out more information on this, but it's really encouraging to see that this is being, compared to the previous government, this is being turned around to say where the previous government were dismissive of unions and made unions' lives as hard as possible, the direction of travel under the new government is a starting place of positivity toward the unions, saying these are the benefits, and in pounds and pennies, there are hundreds of millions. I think they've estimated that just workplace representatives provide an additional benefit to society of, and this is on 2007 figures, of £1.1 billion a year, and recognising the improvements to productivity with reduced dismissal rates, reduced voluntary exits, better workplace resolution of disputes, benefits from training, input of union learning reps and so on, better health and safety. So absolutely brilliant. And so this is the basis they're putting forward for these proposals, which is really useful because, of course, when changes are proposed, the government needs to do an impact assessment and set this out. And you can see they're actually putting the detail into this and putting the hard graft into this basis. So should there be challenges by, I don't know, the CBI or other bodies in some way connected, there's an evidential basis for the positive benefit of these changes, which is really good. And of course, they're linking them to growth and the ultimate benefit to society, which is, again, pretty refreshing. Anyway, I'll get off my soapbox on that, but good to see. Blacklisting. Well, blacklisting is a problem. It's a pervasive problem. And we're talking about, of course, trade union reps, talking about individuals who stand up for their rights or for the rights of others in the workplace being blacklisted. We know it happens. We deal, unfortunately, with a number of blacklisting cases, and it is there. We know previous instances, of course, in the past as well, in different industries. But the emphasis here is on not just the employers or employers' bodies, but looking at protections against AI systems and digital systems that do it possibly without any human input as well. So looking at legislating to improving blacklisting there and spreading the net of blacklisting protections. So more detail intended, but again, a recognition that it's a significant problem. So it will cover, of course, the artificial intelligence side, software that's developed for it, and of course things like employment agencies and others using those, as well as employers and different kinds of agencies too. So that could be really interesting. Protection from detriment. This is, at long last, proper protections are being thought of to protect individuals who take industrial action. So 2 areas really. The proposals are to ensure that there is proper protection against any worker, any employer being treated poorly because they take strike or other industrial action. As I'm sure many of you know, actually our current protections have got a number of big holes in them, and this is aimed to close those holes, which is long overdue, and something the previous government refused to do, and probably put us in breach significantly of our international obligations, and it looks like those are proposed to be filled. And also for those employees who are protected against unfair dismissal linked to industrial action or taking industrial action, I'm sure many of you know there is currently a 12-week cap that applies. The proposal is to remove the cap, so an individual who takes industrial action, on the face of it, will be protected forever against that. And it's not unknown for some employers 2 years down the line, 4 years down the line, to take negative action, maybe dismiss somebody. It might be linked to them being involved in industrial action. Long memories apply, and so this is intended, we hope, and that's how it appears, to give permanent protection for the future, which will be really good. And I think I've covered the trade union rights. Again, apologies for skittering through my notes, but there's quite a lot of detail here, and it looks to me that it's all very positive. There's arguments, of course, they can go further. They can wind the clock back further on, say, industrial action. But I tell you what, I'm happy with what they've done so far. Yes, more, please, but let's be positive about what's proposed here. I think just in general, I'm probably a bit of a cynic and looked at these, but drilling into the detail of this whole package of proposals, there is an awful lot of good stuff here. And I generally think this is the biggest all-in-one change to employment law, positive change to employment law that I've experienced. So there's an awful lot to do, and between now and when most of it comes in. Anyway, moving on to the next slide, so I'm looking at the time. Sexual harassment. Just the next couple of slides deal with that. Of course, sure you're all aware that the previous government legislated to require employers to take reasonable steps to prevent sexual harassment in the workplace. And those requirements came in, off the top of my head, last week, of course, 26th of October, so a little bit before actually. But and that, of course, is a duty, as you'll probably have seen from the ACAS code and other provisions, to train staff, to carry out a risk assessment, to set up proper complaints procedure, so those complaints are dealt with, an evaluation procedure. So some positive changes to prevent sexual harassment. The one thing the previous government didn't do was that they were proposing initially, the private members bill that this came from was proposed to require an employer to take all reasonable steps, and the previous government took out the simple word all. The fact is, the current government are now looking at bringing that in to include all reasonable steps, which in a legal sense, I know this is just one word, but actually increases the requirements on the employer to take all reasonable steps, not just reasonable steps, but all reasonable steps. So that will certainly involve a higher bar for an employer to show that they've done what needs to be done to help stamp out sexual harassment. And if we just move to the next slide, I think that just sets out the current, sorry, that covers third-party harassment because that's linked to it as well. Sorry to bounce around a bit, but when the Equality Act 2010 came in under Harriet Harman's watch, effectively, third-party harassment was part of that, and that made employers responsible for third-party harassment of their people, effectively. What kind of third parties? Well, delivery people or sort of self-employed people who may be coming into the workplace, and even possibly customers, clients, and so on. And of course, I think you probably know David Cameron's government scrapped that, I think in 2013, and the current government are now looking at bringing that back to extend the protections, because currently harassment protections are a little bit of a patchwork quilt, and there are many situations where working people, where employees come into situations where they're dealing with third parties, and this is a requirement for an employer to have responsibility for third parties and to help prevent them from carrying out harassment. So we will see more detail on that, but that's a positive change too. And then if we just move on to the next slide, that just covers what I've been saying about in terms of the current protections. These are the changes that were brought in on the 26th of October. Before we get on, I think that probably is the heart of those changes. And before we come on to the cases, I'll just whiz through some of the other changes. So one big area is 0 hours contracts and what's going to happen here. Now, it's an area we need more detail on, but it looks like the protections will be threefold. So this will allow workers, so not just employees, guaranteed hours, reflecting the hours they previously worked during what's likely to be a 12-week reference period. So this will set up a process where workers are getting some certainty in terms of when they're on 0 hours contracts of the hours they've been working by reference to the previous 12 weeks. And also those workers will be allowed the right to reasonable notice of shift changes. So this is a process where the employer has to give reasonable notice of any changes. And thirdly, where shifts are cancelled, curtailed or moved at short notice, right to payment when that happens unlawfully. So what does this mean in practice? Well, it's quite a complicated approach, but of course, people on 0 hours contracts, and we all know people on 0 hours contracts, family members, friends, and so on. The key problem there is the uncertainty, not knowing how many hours you might have, how many hours you'll work week by week, which gives financial instability to the family, to the individual, makes it harder to pay rent or mortgage or get a rental property or mortgage and so on. So what the idea here is to give more certainty. So creating more certainty in terms of the hours, the notice and compensation for any shifts that are cancelled. So this is a really interesting piece and how that will work. So more detail is required. But currently, I think it shows that the majority, well, a high percentage of people on 0 hours contracts are the youngest people, more likely to be female or in full-time education. So it's looking at improving that. And of course, there are a large number of 0 hours contracts people. I think there's over 1 million, at least officially, and there's no doubt more, but it often gives uncertainty, particularly those obviously in hospitality, retail and health and social care, where the hours can only be clarified maybe on the Sunday before the working week as to which days and so on are working, which has a disruptive impact. So again, positive change here to try and bring more certainty to fixed term contracts. Another quick point is SSP, which I'll just cover briefly, which of course currently is low, but also there are a number of qualifying days, and the plan, or the proposal I should say, is to extend SSP to all employees regardless of their earnings, and those lower earnings should either receive the flat rate of SSP, whatever that will be at the time, or a percentage of their earnings, whichever is lower. And it's also taking away the waiting days. Sorry, I refer to qualifying days, but waiting days. So it would mean that SSP will be paid on the first day of sickness, not the fourth day of sickness. And also the enforcement of SSP would be by the proposed new labour enforcement body known as the Fair Work Agency. So that's the term being used, which I'll talk about in a second. But it could mean that SSP enforcement is carried out rather than an individual going to an employment tribunal, is by report to the enforcement body who would then take action. And we hope that that would work a bit like the national minimum wage compliance bodies, compliance units within HMRC currently, who they can vary region by region, but some of them are very effective in getting national minimum wage payments. and it would work in a similar way. And I'll talk about the Fair Work Agency in a minute. So that's an improvement to SSP. And then the Fair Work Agency, again, more detail required, but the plan is that this is an amalgamated body of the current different agencies that have labour enforcement powers. And we will see, I mean, for example, I mentioned HMRC, National Minimum Wage Compliance Unit. The question is whether this would include a body like Health and Safety Executive and other sort of smaller bodies that operate in terms of things like gang masters, in terms of areas like that, and bring it into one body, which has got to be sensible. And it would be helpful, I think, from our point of view, that there is a government body that enforces those, because, again, I think HMRC have been so effective in many ways for national minimum wage. But that's because it's HMRC, and not many employers want to take them on in their right mind, whereas an individual having to go to an employment tribunal is possibly less of a threat and takes longer. So that could be a really, really good mechanism. There are some other proposed changes as well, things like bereavement leave, which probably would be unpaid. So bereavement leave is proposed, extending parental and paternity leave to a day one right. So bringing those in rather than having to have 26 weeks and a qualifying service. Those are the main ones. And then there are some other changes proposed outside the employment rights bill, covering things like equal pay, and a proposal that would be extended to cover other protected characteristics and some other areas like that. But quite a bit of useful information here. Hopefully you agree, and some useful proposals. Quite a lot to cover just now, and we will be issuing, and I'll send it on to you, a kind of a list as these things develop of sort of likely changes and timescales. But it looks like the majority, again, 2026, but positive changes. So, Chris, if you don't mind moving on to the next slide, I think, yeah, what I'm just going to do is cover a couple of recent cases. And I think certainly you'll have heard of this one, but I thought it's useful just to go back over it because it's a very useful one. So this is the Usdaw case involving Tesco's. And I think it's useful just to go back to the heart of what this case was about, because it covers things that you no doubt deal with on a day-to-day basis, which is contracts of employment and collective agreements and union collective agreements. So this case concerned Tesco's workers at their distribution centres in Lichfield and Daventry. And in 2007, Tesco's was what it calls rationalising its distribution centres and looked at closing and redistributing workers within its distribution centres. And so they entered into a collective agreement with Usdaw to pay relocation pay, what they called retained pay, to employees who relocated to other Tesco sites. And this was quite a significant amount of their wage, because those employees who said, yes, I'll take retained pay, please, I'll remain with Tesco's, but I'll work at another site, it became about a third of their wage. It was put to a ballot by Usdaw, and the majority was in favour, and a collective agreement was entered into. Now, this is quite a useful case in terms of the wording of collective agreements. So I think you're probably aware, but let me run through the wording and directly quote. So it said the collective agreement that was entered into by Usdaw and Tesco's said, retained pay will remain a permanent feature of an individual's contractual eligibility. And then the supporting document said, retained pay is guaranteed for life. And we want to introduce retained pay to ensure there is long-term protection for you. So let's just look at that wording, permanent and guaranteed for life. That sounds good, and it sounds, from the workers' point of view, that's a very firm commitment by Tesco. However, it continued, so it went from 2007 till 2021, when, in kind of typical management speak, Tesco notified Usdaw of the following. Retained pay arrangements achieved what they were designed to achieve, but we feel it is now the right time to phase those arrangements out. Why was this? Well, two things. Obviously, since 2007, Tesco's had taken on other workers at the sites, and the other workers didn't receive the retained pay. So there was an element of sort of envy for those workers who were on the retained pay. Okay. But secondly, unbelievably, Tesco couldn't make their payroll software work with retained pay. They said that we cannot get it to work within our system, and therefore retained pay has to go. And let's remember, this is a third of someone's pay. So Tesco, Usdaw wouldn't accept it. Tesco forced it through, and Usdaw went to the High Court seeking an injunction and a declaration that the retained pay was contractually binding. It was permanent. It was guaranteed for life, and they succeeded. And many commentators were surprised, because typically injunctions aren't granted by the High Court for these types of things. Often the traditional contractual interpretation of the court is that these terms wouldn't normally be suitable for being dealt with by an injunction. So it was, and so many were surprised, and so were Tesco's. So Tesco's appealed to the Court of Appeal, and the Court of Appeal said, yes, it is inappropriate for the High Court to have granted an injunction. Ultimately, Tesco, as the employer, has the ultimate freedom to dismiss. They cannot be bound by this. And of course, the meaning of that is that permanent and guaranteed for life, it wasn't. However, Usdaw went to the Supreme Court, and the Supreme Court, in a lengthy judgment covering all kinds of contractual principles, pretty much came back to the point. Permanent means permanent. Guaranteed for life means that it's permanent, and upheld it. So, and that Tesco couldn't just withdraw from it. So a really important decision, and one that's firmly in favour of unions and workers. But it is very important to remember that it relates to the wording used, and permanent being permanent. So there's a lot of legal analysis of it, but ultimately very much reflects the terminology used in a collective agreement. And in practice, often these don't contain things like permanent, because most employers won't commit to that. Tesco did, and Tesco was stuck by it. Often, sometimes these things are more aspirational. You know, we will aim to do this rather than we will do this and it's permanent. So we can't get too excited about it, but it's worth bearing in mind that possibility of an injunction and the civil court being in favour, which is really helpful. So a good bit of news and a good finding by the Supreme Court. And then just moving on to the next slide, I think we'll just look at a bit more of a negative case, I'm afraid, and I think it's worth just going into the detail of this one too. So this concerned an NHS worker. NHS worker was notified that his assignment with the NHS was to be terminated as it came to light he had an unspent criminal conviction, which was found to be misleading, which he hadn't declared. So he was dismissed because he'd been effectively dishonest and hadn't declared his previous conviction. Now, he didn't have ordinary unfair dismissal rights because he had less than 2 years service, but he actually alleged that, no, actually I've been dismissed because of my belief in English nationalism. So I have a protected belief, and therefore it is unlawful to discriminate against me. And the real reason I've been dismissed is because of this. He'd previously stood for political office, and I think it was quite obvious on social media of his views and his political views. And he was saying, no, this is all my excuse. It's not because of that. It's because of this. So the Employment Tribunal and also the Employment Appeal Tribunal had to analyse his belief, and they had to also identify the Granger principle. So if we just turn to the next slide, there are some fundamental factors that a tribunal must consider to see whether a protected belief is protected, so whether it qualifies. And I'll just quickly cover those. This is important because there's often a range of different beliefs, of different political viewpoints. And so an employment tribunal has to have a mechanism to identify those that should be protected. So it has to be genuinely held. It has to be a belief, not an opinion or a viewpoint. And it has to be based on the present state of information available. Thirdly, it must be a belief as to a weighty and substantial aspect of human life and behaviour. Fourthly, it must attain a certain level of cogency, seriousness, cohesion and importance. And fifthly, and this is where Mr. Thomas didn't succeed, it must be worthy of respect in a democratic society, not be incompatible with human dignity and not conflict with the fundamental rights of others. So let's look at that. So what beliefs have been found to be protected? Well, belief in Brexit ultimately could be protected because it meets those categories. Many people might not agree with it, many people might. But again, it has a level of cogency, it covers a weighty and substantial aspect of human life, it's a formulated belief. Ethical veganism, covered, and it's been found to be covered because again, it meets those categories. What wouldn't be covered? Well, Nazism and far right beliefs wouldn't be covered because at the very least, they would not be seen to be worthy of respect in a democratic society, and they would conflict with human dignity and fundamental rights of others by the very nature of their belief. So the Employment Tribunal had to boil down Mr. Thomas's principles. Now, Mr. Thomas had a belief in English nationalism, and the tribunal found that on its own is potentially protected. A belief in Scottish nationalism, English nationalism, Welsh nationalism, and so on will be protected. But he went further than that. They actually said his English nationalism was linked to a number of anti-Muslim comments that he'd made, including the hashtag remove all Muslims and that Islam in its current form should be banned from England. So his beliefs actually went way beyond just English nationalism because he was actually anti-Islamic and sort of a desire to remove Muslims forcibly from the UK. So it was found, very unpleasant, but it found that that would not, of course, qualify because at least by the fifth category, it's not worthy of respect in a democratic society. And they found that its shared features with Nazism, for instance, and extreme right-wing views that are incapable of protection and obviously massively conflict with the rights of others. So it's worth remembering here because whilst these cases can be relatively rare, they've cropped up more and more recently, particularly when it comes to beliefs. I mean, I won't even mention today's election, but there are different varying beliefs in place there between Trump and Harris, of course, but also much more widely with situations in Ukraine, situations in the Middle East, different beliefs. And there has been a rise in cases involving clashes of political beliefs in the workplace. And the touchstone really to look at that is to go back to the Granger criteria. And I do feel sometimes for an employment tribunal having to navigate this territory. I don't often feel too sympathetic for employment judges and tribunals, but in this area, it's a very sensitive area, of course. And we also get into questions in terms of transgender rights and other rights as well, and religion and so on. So it's a real clash. But I think when it comes to political beliefs, this is a really good recent case that reminds us of those key principles. And I think we can use that as a touchstone to identify which areas are likely to be protected. It's a very sensitive point because you can bet your bottom dollar that everybody who potentially thinks they'd be discriminated against on the grounds of their protected belief believes their belief is protected and are not too willing to bend and find that their belief may not be, or that their belief is outweighed by another belief. And of course, we can sometimes get into the religious fray with a clash between certain religions and other beliefs and so on and so on. So it's a very sensitive area, but it's an area also I think the employment tribunals are pretty good at navigating and have this and other tests to help guide them through it, but not easy. And of course, in a case like that, there is always a very unhappy party who then potentially wants to appeal. And there are a number of current appeals going ahead by different, the losing party effectively in a number of tribunal cases and so on, who are appealing at the moment on these very principles and those clash of beliefs. Very sensitive area. So there we go. I think I'm just slightly over time. So hopefully I've covered everything as best I can, and really I think if I'm happy to answer any questions, anything arising from the government proposals, the cases, or in fact anything else at all employment law related.
Thanks ever so much, David, for that presentation. Again, as always, very informative. And as you've said, for this employment bill stuff, it would be great if some of it could come before 2026. So it'd be interesting to see how it all unfolds. Fiona, have we got any questions in?
There's just one in the chat from Mike Calvert. Hi, Mike. Regarding the access to the workplaces, and he's asking, well, presumably there's not permission to barge in where there is already another union or a representative body in place.
That will be interesting. It's not been addressed in any of the documentation, so it's going to be really interesting to see how that works out. But I imagine there's got to be some limitation on that in terms of sort of inter-union competition and how that will work. So that's going to be an area where there's a bit of a potential flashpoint. So we will see. But I've not seen anything on that as yet. I'm really interested to see how it will work in terms of the access. But I think because the access will be governed ultimately by the CAC. And I should say, the CAC, the aim is to try and resolve these things through mediation, through discussion. But if they can't be, the CAC will have the power to issue penalty orders and potential fines and things. So we shall see. More to come. There's a lot to look at over the next year or two. It's exciting times. It's also going to be head-scratching times because there's an enormous amount of detail, enormous amount of consultations, but worth it because some big changes here. And I think the right of access here is really good and just so refreshing after the last 14 years.
Yeah, I mean, it's really positive stuff, and it's great to see. And I've got a couple of questions, if you don't mind.
Of course.
The first one is, I mean, how likely is it that this will be watered down by the business lobby? Have you any sort of feeling about that?
Well, again, I'm probably a bit of a cynic sometimes, but I'm cautiously optimistic that it won't be. Certainly, I think a lot of business response has been quite muted, and hopefully that's an acceptance. I think there's also been quite a lot of positive feedback from employers that this is what we need. I think there's a recognition there in the society in this country that workers have been at the brunt of things for so long that actually we need to improve things. And I think a recognition that other European countries or other large economies around the world have much better protections in place. And so we're sort of behind the curve and hopefully we can catch up. So we shall see. Also, I think in terms of the ministers involved and the Deputy Prime Minister's involvement, she seems to have very much staked her reputation on a lot of these changes, and certainly the trade union ones. And she's not a person I particularly want to fall out with. So we shall see. But as ever, it's all down to politics, isn't it? But there's a lot of commitment made, a lot of detail. And I suppose, again, probably the final point is, I know sometimes it's, again, I don't want to be rude, but hard to get too excited about Keir Starmer and his presentation style. But he does seem to do his homework and be very methodical. And I'm not suggesting he's been all over this, but certainly the approach taken is pretty detailed and pretty impressive. In the previous government's consultations, it was always a bit thin, whereas here, I get the feeling that quite a lot of homework has been done in advance. Not really been with a great fanfare, but there's quite a lot of depth here to it, which may make it hard to resist it, because it looks as though the arguments, and like just trading access and the fact that they've identified that unions, just by having workplace representatives, contribute billions to the UK economy. That's a real firm foundation for saying, here's the evidence base for it. So I'm hopeful that that's going to be a determined approach to work through the detail. I know I'm a kind of cautious optimist. I don't want to let my optimism run away with me, but it does seem that the foundations are quite firm here. So let's hope that that's a sign that the rest of the house will be built over the next year or two.
Thanks. The other question I had was around the trade union levy. Do you think they'll keep that, or has there been any talk of
I apologise, Fiona, I should have mentioned that. The talk that again proposal is that's going to be scrapped.
Oh, brilliant.
So again, sorry, so much detail. Like I say, we'll be putting something out. We're working through a lot of this ourselves in terms of the implications. But yeah, the proposal is the levy will go, and also, and I do apologise, and I should have mentioned it, the political fund, new members joining a trade union, the proposal is they'll be automatically opted into it unless they expressly opt out. There will be some other changes as well that are kind of regarding reporting requirements, the certification office. So it will reduce down things like reporting industrial action. I mean, these are all sort of administrative burdens, which sound, you know, to sort of many members of the public thought, well, so what? But actually, I think we all know that the reporting requirements are really quite onerous, and they've built up over the last 5 to 10 years under the previous governments to build up the workload on unions in a way to, you know, frankly, I think it's politically driven to add extra cost and burden and time and so on. And it looks as though those are going to be lightened. I think obviously the sort of the proof will be the pudding over the cliche, but if for example electronic balloting comes in, that will reduce the burden quite significantly, and also no doubt improve member engagement as well, because it's just more straightforward than the current postal system, which is awfully old-fashioned and time-consuming, and means, you know, for example, going on industrial action just before school holidays is riskier, because of course it may be a number of members are on holiday and then might miss the boat through paper form, whereas you do it electronically, they may pick it up when they're on the aeroplane or something. You know, I mean, simple things like that will just improve efficiencies. And so, yeah, looks as though the levy should hopefully be scrapped.
Thanks very much. Has anyone else got any questions?
I've just had a quick look, Fiona. I can't see that anybody's got their hand up. But if anybody has got any questions that they want to ask David while we've got him, have another flick through, make sure nobody's put the hand up. No. Well, thank you very much, David, once again for coming and giving you know, a really good update for us. You know, we really appreciate the time that you give and the updates that you do for us each year. And yes, looking forward to see how all of this progresses over the next couple of years. So thank you very much, everybody, for attending today. And we will be in touch shortly with another newsletter just to tell you what's going to be coming in 2025. So thank you ever so much, and we will see you again soon. Thank you.
Thank you. Thanks very much. Have a good afternoon.
You too. Bye.
Bye-bye.